Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition, we're looking at a criminal case where the defendant tried to argue that he was too intoxicated to consent to search here. This is the unreported case of State versus Green. The defendant appealed his conviction and sentence for first-degree vehicular homicide. Witness saw a man who was drunk cross the street at an intersection, fall on his back, and then be run over by a car. Defendant driver stopped and appeared to be intoxicated, also in slurring his speech. The investigating officer testified the intersection was well lit, and he noticed defendant's eyes were bloodshot, and he smelled of alcohol. Defendant consented to a search of his car, and officers found an open bottle of rum. Defendant signed a blood alcohol content consent that did not state he had a right to refuse the test. His BAC was a .21. Now in New Jersey, the legal limit is a .08, much less. The trial court denied defendant's motion to suppress the BAC, finding the absence of explicit language regarding the right to refuse consent was not dispositive. The trial judge suppressed defendant's statement made after he was placed in the car, in the patrol car. However, the appellate court affirmed defendant's conviction, finding the trial court did not abuse its discretion in admitting defendant's double hearsay statement he made to the officer, and the admission of that statement did not alter the outcome of the case. The court also rejected defendant's argument that he was too intoxicated to consent to the search of his car. The court also found there was exigent circumstances warranting blood draw absent defendant's consent. And that's the unreported case of State versus Green. For more information on other cases dealing with DWI and blood draw and consent, visit website njlaws.com. And for representation, contact Kenneth Vercammen's office in Edison at 732-572-0500. Thank you. Good luck.